Good morning. My name is Cameron McElhenney, and I serve as the Director of Training and Education for the National Association for Civilian Oversight of Law Enforcement. I would like to welcome you to the second webinar in NACOLE's 2017 webinar series, where today we'll be discussing credibility assessments. Before we begin, I would like to go over a few things regarding today's call. During the webinar, all attendees will be in listen-only mode, which means you will be muted. As we begin, however, you will have the ability to type in any question you might have for our speakers. When we come to the question and answer portion of the webinar, the questions will be asked and answered if they have been received. During the webinar, you may also send any questions you might have for me as the webinar administrator in the same manner, and I will answer your questions as quickly as possible. At the conclusion of the webinar, each of you will be given the opportunity to complete a brief survey on today's event. If you could please take a few moments to complete the survey, it will help us as we move forward with enhancing and expanding our webinar series. With our housekeeping duties out of the way, I would like to introduce you to today's speakers. First, we will welcome John Alden, who has been an attorney for the San Francisco Department of Police Accountability, formerly the Office of Citizen Complaints, since May of 2016. Prior to joining the Department of Police Accountability, he worked for over 7 years as an attorney for the San Francisco Police Department's Internal Affairs Division. He has helped conduct hundreds of police misconduct investigations in San Francisco and presented cases regarding those investigations for courts and administrative boards. He also supervises the Department of Police Accountability training program. Next, we will welcome Jayson Wechter, a former member of NACOLE's Board of Directors. He has worked as an investigator for over 35 years, including 18 years at the San Francisco Department of Police Accountability, where he conducted hundreds of investigations, including officer-involved shootings, serious use of force, and allegations of biased policing. Mr. Wechter also has worked as an investigator for the San Francisco Public Defender's Office and as a licensed private investigator specializing in criminal defense and workplace investigations. With that, we will now turn it over to John Alden.
Good morning. This is John Alden. I'd like to talk to you a little bit about credibility determinations and some ways that we have been making credibility determinations in our agency. Some of these ideas I hope will be helpful to you in your agency as you're thinking about how to make these credibility assessments. I'd like to start by providing a little bit of background about how I might recommend you use this material. The first thing I want to point out is, of course, I'm not your agency's lawyer. I'm a lawyer for a different agency, so I strongly recommend that you run anything you see here past the lawyers in your agency to make sure it matches with the advice that they want to give to you. Secondly, I only practice law in California, so some of the rules that I'm going to talk about here are taken from California law. The law in your state might be similar. It might be a little bit different. There might be particular laws that apply to the administrative proceedings that you're working in as you work on police discipline cases, and you should make sure you double check those too. And of course, if the attorney from your agency suggests you do something different than I'm suggesting here, I would of course defer to them. But that said, let me walk you through how we've been doing these credibility assessments here using some law in California that might help you figure out some law in your state that would be useful too. Cameron, the page down or next page function doesn't seem to be working. Could you advance the slide for me, please? Thank you. One of the things that I always try to get across to our new investigators in particular is that credibility determinations in this field are really not that different from credibility determinations that people might make in their everyday life. You probably have someone in your family that you thought was credible or not credible. Those of you who are parents probably make credibility determinations about whether your kids are giving you the straight story every day. Even in an office environment, people sometimes get the impression that someone is giving them a complete story or maybe gave them a story that's accurate from their perspective, but maybe doesn't include all the relevant perspectives that you need to figure out what really happened. We do these things often without thinking about them very much. But in this field, we have to learn to articulate those credibility determinations so that other people can perceive the factors that you're perceiving. Because we make these determinations often on an automatic or instinctive level, it can be difficult to step back and think about how to break them down into specific articulable factors that you could say write down in a report or use in an oral presentation to a hearing board or just in a conversation with your supervisor about why you found one witness credible and the other not. But once you learn to articulate those observations, you'll be able to then walk other people through them in a rational and organized way. And one of the things I think is important about that process is that those observations and conclusions that you've articulated should meet the applicable evidentiary standard for your process. Now, here in California, as a general rule, when we're doing police discipline cases or any kind of employee discipline case, we use the preponderance of the evidence standard. That's probably the case in most of the agencies that are on the line. I have heard of a few that use a different standard. But the main thing I want to point out here is that whatever the standard of proof is, the evidentiary standard that you're held to, I would recommend that you take a look at the law that's used in your area for credibility determinations in fields that use that same standard. So for example, here in California, we use the preponderance standard for things like civil cases, car collisions, contract disputes. And so while there is not a body of law about credibility determinations in administrative cases like ours, because we use the same standard as those other civil cases I just described, we've been using the same case law from those other related fields because the evidentiary standard is the same. Preponderance, at least in California, simply means that there is more evidence in favor of one side than the other. 51%, if you will, as opposed to 49%. So it simply means a little bit more evidence in favor of one or the other side. For this reason, one way to describe credibility is simply a measure of the weight of the witness's statement. That 51% likely that that statement is accurate or true, or only 49% if you're using preponderance of the evidence. It's not a value judgment about the witness, and I think this is where a lot of us get tripped up in our work. Deciding that someone is or is not a highly credible witness doesn't necessarily mean that you're concluding that they're a liar or that they're a bad person or that they are in general never worthy of belief. It simply means that there are issues, specific observations you can make in this case that mean that lead you to believe that their perception, their ability to describe what they saw was strong or was weak. And often these are non-judgmental factors like simply where the person was standing when they saw the events. So keep in mind that lying, while it's a strong moral judgment, is seldom what you're really looking for when you're making a credibility determination. Another thing that we often rely upon when we're using the preponderance standard to determine credibility is circumstantial evidence and logical inferences. That means, say, for example, that you have one witness who says, I looked at the intersection and from the direction I was looking at, the light was red. Well, you can usually safely infer that the light in the opposite direction would have been green, because that's normally how traffic lights function. And that's a perfectly acceptable thing to do with witnesses and witness credibility. What we're not doing is necessarily becoming convinced or certain about what happened, at least not under the preponderance standard. We're simply concluding that one is more likely than the other. For those of us using the preponderance standard, we don't have to be convinced that one story is true or that one person is telling the truth. It's not required that we reach a level of certainty that's beyond a reasonable doubt. There aren't any presumptions one way or another. And your gut sense isn't by itself enough either, unless you can explain it persuasively and break it down. So with those things in mind, we've taken a look here at jury instructions that are used in California for juries that are called upon to make credibility determinations in cases where they use the preponderance of the evidence. Now, in your jurisdiction, you probably have some kind of jury instructions. Here in California, we actually have two different sets, and some people debate which is better. You might want to talk to the attorney in your agency and find out if there are parallel jury instructions that you could point to. One of the reasons I like jury instructions is that in most places, they're created by judges and attorneys who have been working on credibility issues for some time, and they've taken the applicable law in that jurisdiction and condensed it down, simplified it into a set of fairly straightforward directions to lay people on juries about how to make credibility determinations. So you know that these jury instructions already have been vetted by someone else with significant expertise, and that they're generally accepted in your community as a logical, adequate basis for making a credibility determination. I'll be quoting here from a set in California called BAJI, B-A-J-I, and as you can see on this slide in the middle right side, each jury instruction has a number. This one is called 2.20, believability of a witness. One of the things that that jury instruction says to juries in civil trials is that determining the believability of a witness, you may consider any matter that has a tendency to reasonably approve or disprove the truthfulness of the testimony of the witness. I want to really flag for your attention there the phrase in the middle, you may consider any matter. So juries are given very broad discretion about what to look at least in our jurisdiction. There are only a few rules about what they're not allowed to look at. And this, again, embraces the idea that a credibility determination is something that everyday people do all the time, and they should feel comfortable doing it in a legal context just as they would in any other phase of life. Now, one of the things that jury instructions often hit straight away, and in this case in California they hit almost immediately in our jury instructions, is that discrepancies in witness testimony can be important, but should be treated with some caution. Here you'll see this jury instruction says that discrepancies in a witness's testimony, or between the witness's testimony and that of another witness, don't necessarily mean that you should discredit the witness. It is the case in this jury instruction that juries are warned that failure to recall is common, innocent misrecollection is not uncommon, and that two people witnessing an incident or a transaction will see or hear it differently. It is, I think, common in our culture, because of a lot of the TV shows we watch, to think that the very best way to determine credibility is to see if someone has made an inconsistent statement over time. And that's not a bad one, but I think what's more important is to figure out if the inconsistency really makes sense or not. If you interview someone a year after an event and they have a minor inconsistency about, say, the color of a shirt someone was wearing, or whether it was 55 degrees outside or 60 degrees outside, that's probably something you'd expect to see over time as someone gets further and further from the event. If someone says two completely different things on the same day, that's, of course, much more significant. So one of the things I tell our investigators is, yes, you're going to want to look for inconsistencies, but you'll need to put them in some kind of setting to understand whether they're important or trivial. Some of the other factors that we see in the jury instructions, I think, are actually a little bit more useful than consistent or inconsistent statements, except for some extreme inconsistent statements. Here's a list of some of the factors that are used in the jury instructions here. Demeanor and manner of the witness, meaning like, are they hostile, or do they seem like they're paying attention? The quality of the testimony, is it detailed, is it easy to understand? The next three relate to perception, memory, and narration, which are classic criteria that, for those of you who've been through law school and had evidence class, probably came up really early in the course. Was the person able to see or hear the thing that they're talking about at the time that it happened? Does it seem that they're able to remember what occurred fairly well, given, again, however much time might have passed? Are they able to explain what it was that they saw such that you can really understand what they're relating back to you? It's not uncommon that witnesses will have failures of perception memory, or narration. But none of those mean that that witness is a bad person. They just might not be very reliable. You might have a witness who has great memory and really good narration, but just simply didn't perceive the events that happened. About a week ago, by coincidence, I was standing at a newsstand here in San Francisco, and I heard a crunching sound and heard several people scream and heard a thud. I turned to my right and looked, and there was a woman who was lying on the ground in front of a car. The woman was lying in a crosswalk, and the car was partway into the crosswalk. So naturally, I inferred from that she had been hit by the car. But I didn't actually perceive that. I gave a statement to a police officer later, and I could tell that I might not have been the most credible witness because I didn't actually see the events occur. But at least I was able to describe to him that I had perceived the sounds, and I had seen events immediately after the collision that were consistent with it being the kind of collision I thought it might have been. And I made sure to keep those memories fresh in my mind as I was waiting to make the statement, and I tried to narrate them in a detailed way. I think there was at least one other witness there who was simply so excited in a negative way about what she had seen that she just could not narrate what she had observed. I think she probably perceived it better than I could. But because she wasn't able to walk the officers through what she had seen, because she was so stressed by it, her narration was poor. Both of us are good people and well-meaning, but each of us had different deficits in our credibility. Bias is a very important factor that you'll see a lot, especially in police cases, and it can cut either way. If you have an officer who's particularly biased against an individual because they've had a lot of encounters with them and are frustrated with them, that may make the officer less credible. Same could be true of the complainant. Past statements and corroboration for any of those past statements are certainly important. I'm sure you've seen some of those before. But juries are also invited to consider what the witness's attitude toward the case is. Someone who feels strongly that there were maybe a third-party witness to the events, but they feel it's important to come forward and tell the truth about what they saw, has a great attitude that really enhances their credibility. If someone's attitude towards the case is that they don't think that this particular tribunal is a valid forum for resolving whether or not the officer committed some misconduct, then their attitude towards the case might actually impair their credibility. One of the things I want to really highlight in this slide is the final line there, the witness's prior conviction of a felony. This is a really hot topic. Here in California, increasingly there's some debate about whether this should or shouldn't be a factor. We have a rule in California that judges have some discretion in deciding whether to allow juries to hear about past convictions of a felony. Last I checked, in federal law, there was a rule that judges had to tell juries about past conviction of a felony. I strongly urge you to double check this issue with law in your jurisdiction before you decide whether you should or should not consider it. Many other jury instructions are available. I won't go through all the ones here in California because there's simply too many. Some talk about destroying, altering, or hiding evidence, failure to produce evidence that might be logically related to someone's claim. People who are willfully false about one issue are sometimes said to be less credible as to any other issue. You may find that is or isn't useful in your jurisdiction. I think that particular rule is also one that's subject to some controversy amongst the states. If you have an officer who is confronted with an allegation of wrongdoing, and there is some evidence that you then show them that suggests that they actually committed the violation, and they can't explain or deny that evidence in some way, that might be very significant as well. Here in California, you'll see that Badge 2.04 invites juries to take a look at that. You might want to take a look at whether that's an acceptable technique in your jurisdiction as well, and that might shape the way that you conduct your interviews. Maybe that might change your mind about the extent to which you'd confront or not confront an officer about the material that you have. Another issue that I think is very important to get across to our new investigators, and again, I think this comes from a cultural bias from our television shows, is that, at least in California, we have a rule that the testimony of any one witness that you believe is sufficient to prove a fact. It's not necessary to have 2 or 3 or 4 or 5. It's not necessary to count the witnesses on either side of an issue. Rather, the issue is to determine which of those credibility factors we assessed above apply to the testimony of each witness and to figure out which one is the most credible. You might have one person who directly viewed a traffic collision in an intersection who's unrelated to anyone involved in the case, and they'd be highly credible. You might have 5 other people who had a different perception of what was going on, but perhaps they were in a bus down the street and just had a very poor vantage point. You might, for that reason, decide to disregard the other 5 people and rely heavily on that first person who had the better vantage point. That's perfectly acceptable. It's also the case that we don't necessarily have to have witnesses who are completely uninvolved in the incident. I think most of the time in police misconduct cases, the majority of our witnesses are people who were intimately involved in one way or another with the events. But you should still go through, in my opinion, a credibility determination with each of those witnesses, even though they might have known some of the parties involved. Maybe they were a coworker, one of the people there. Maybe they were a companion of the person who was arrested. And still go through in a thoughtful way each of those credibility factors before we simply decide, well, there aren't any independent witnesses, so we can't make up our minds. Finally, in the kinds of cases that we're working on, there may be some advisements that are given to the officers before they're interviewed. In some jurisdictions, there might be advisements that you give to some of the witnesses before they give their interview to your agency. Those advisements might cause one to think that the statements made in those interviews are more reliable than statements made simply on the street or in some other venue. Employees, for example, are often given the right to a representative under the Weingarten case law. There might be state and local rules about certain advisements they're given about their right to have, say, a recording of the interview or the like. They might be advised how the interview might be used against them in the future. All of these things usually imply that the person being interviewed is going to be more likely to be thorough and truthful. Conversely, if you have an officer who is accused of some significant wrongdoing and they know that coming into the interview, perhaps that means they have some incentive to not be entirely forthcoming in order to hide whatever wrongdoing they might have engaged in. That concludes all of the slides I have. I'll be available for questions at the end of this. Jayson Wechter is going to go next, and he'll give you some more specific examples from his experience that he uses in making credibility determinations.
Thank you, John. So I'm going to talk about credibility assessment from the perspective of someone who's conducting an investigation or reviewing or evaluating an investigation that someone else has done to determine whether it was thorough and allows appropriate credibility assessments. So I took, these list 8 credibility factors that are very similar to John's. I looked at the jury instructions in California, New York, and federal jury instructions, and also at some other sources of information that are available to you as PDFs, including the California Department of Fair Employment and Housing guidelines that list credibility factors. And so I'm going to take you through these in a more detailed level and maybe a little rushed, but hopefully we can catch up with anything through the questions. Cami, I seem to be having trouble getting to the next slide. Could you? Thank you. So the first, obviously, as John said, is perception. And these include things, in addition to eyesight and hearing, like someone's physical condition, illness or injury. If a witness is walking down the street and they're suffering from a migraine headache, if they have a severe pain, toothache or other pain, they're likely going to be a little distracted, may not be paying the same level of attention to an incident that you or I would if we're calm and rational and not distracted. Alcohol, medications, drugs, you need to look at how they affect the individual, both from their subjective perspective, ask them what effect does this have on you, and also the objective perspective by doing some research and seeing what effect that, that substance would typically have on someone. Emotional state, Is someone relaxed, calm, versus someone who's just very upset, angry, just been fired from their job, gotten some bad news? That's also going to affect how they're going to be perceiving something and how they're going to recall it. In terms of the environment, their distance, both their estimate and the actual distance as you can measure it. Sight lines are very important, as this photograph shows. Someone at the position seen in the photo will look through that bus shelter and they'll see something. But they're not going to see everything until they move to the right or the left and get that bus shelter out of the way. Yet when they're recounting it, they're going to be telling you what they saw from the very beginning. And their ability to see obviously is a factor, and that's something that you're going to need to test as part of your investigation. When there's not natural light, artificial lighting, the location of the lights is important. Also, certain types of artificial lights can distort colors. Noise level at a location can be very relevant. Again, the more noise there is, the more sensory input there is for someone to deal with. It can also go to, if you're in a very noisy environment and someone describes an officer shouting, they may be shouting or raising their voice because of the ambient noise. Could we have the next slide, please? The arrival time is, when did someone essentially come in on this film that's playing? Were they there from when it started, or did they come in at some other point? What did they first focus on? And again, people tend to fill in gaps. They may make assumptions about what happened. This is classically when someone sees officers making an arrest, using force. They may make an assumption. They may not see everything. They may fill in, make some conclusions about that. I always like to determine someone's activities before and after the incident, and there are a lot of valuable things that can come from this. You can attempt to confirm or refute particular things they told you about what they were doing beforehand or what they were doing afterwards. So for instance, if I have a complainant who says, I wasn't selling drugs, I just got off the subway and was walking to my friend's house, well, you want to ask, can you confirm that they were on the subway? Did they have proof of payment? Which friend were they going to see? Where were they? You can contact the friend. Were you expecting them? Because any individual fact that someone tells you that you can prove or disprove is going to enable you to better evaluate their credibility. Also, their activities beforehand give you an idea of their frame of mind at the time. And when you find out what they did afterwards, that can give you identities of people they spoke to who observed them immediately afterwards. And again, those contemporaneous statements to another individual, if they're consistent with what they're telling you, can be powerful for confirming their credibility, or they can contradict what they're telling you and diminish their credibility. Focus and distractions, as I mentioned, the research has shown we have a limited ability to focus on things. That's why people are urged not to text or talk on their cell phone while they're driving. Familiarity with the location is also going to be relevant. If someone sees something that happens on the street they live on, they have a very close familiarity with the placement of objects, with sight lines, spatial relationships, whereas if someone who's a tourist and is at this location the very first time, they're not going to be as sure of those things. So that's something you want to explore. Expectations based on someone's prior experience is very relevant. Have they had any similar incidents or seen similar situations? So for instance, if someone had prior contacts with the police, it may have given them a negative perception of them, and they may think the police are behaving in this instance the way they did when they had their interaction. Can we have the next slide, please? So the time frame of the statements, if someone, you want to determine, has someone been interviewed before? Have they given any previous statements? How that was documented? Were there notes taken? Was there an audio or video recording made? That enables you to look for consistencies or inconsistencies to statements. And you also want to see what statements they've made to others, friends, family. Have they made any social media postings? A lot of people now post anything that's significant in their lives on Facebook or on other social media. So that's something you want to explore, both by asking them and possibly by doing some independent research. Post-event influences can have a tremendous effect on how people recall things. Obviously, media and outside sources of information were awash in media, online information. So you want to ask, were they aware of that? Did they see that? Who else did they speak to who had some knowledge or information about this? And when, where, what was said? And again, you may want to talk to those people to ask what the content of the conversation was. Prior interviews can have a tremendous influence on how someone is recounting an incident, particularly if they were asked open-ended versus leading questions, if they were asked suggestive questions, if they asked questions that contained information they did not previously know. There's been a lot of psychological research regarding how manner of questioning can affect the response. Elizabeth Loftus, L-O-F-T-U-S, has been a pioneer in this field. As a quick example, she did an experiment showing people film of a vehicle collision and then questioned them about the speed of the vehicles, and found that the more active a verb that was used in the question, the higher the speed estimate. So when they asked how fast were the cars going when they contacted one another, they got a lower speed estimate. When they asked how fast were they going when they smashed into one another, they got a much higher speed estimate. Quality of recollection. The level of detail, you want to see, is this consistent with what they were able to perceive? And again, we look at sight lines, lighting conditions, spatial relationships. Are they providing less information than they should have been able to provide based on where they were, what they could see? Or are they exaggerating what they likely were able to perceive and hear? Their qualifications and experience plays into this. We obviously expect a police officer to be able to recount what happened better than an untrained civilian. Police officers are trained observers. They are trained storytellers, trained to testify in court and provide a clear narrative account. So if you have an officer who is giving a very sketchy account, who is giving minimal details, who is not being responsive, that's something to examine and try and seek the answers for that. And I've gone to the extent of listening to officers' previous interviews. We would audio record our interviews to see, are they providing more or less detail? What is the quality of the narrative been in the past, and is it consistent with what they're saying now? Is the level of detail consistent throughout their account? So for instance, they're providing a lot of detail about what led up to this, but then becomes much vaguer about what happened during the incident itself. So you want to explain those inconsistencies through questioning, and that, again, that will may be very relevant to how you're going to evaluate that individual's credibility. Are there unexplained gaps? Does the person use phrases like, the next thing I remember, or before I knew it? You need to explore that and see, are they intentionally omitting information, or was their intention diverted? Were they not paying attention? Does it make sense? The accuracy, you want to try and isolate any fact that you can prove or disprove through other evidence, particularly reliable evidence such as video, records, dispatch records. Are there assumptions or conclusions that the witness has incorporated into their account? And people do this frequently. We make judgments all the time. As John was saying, he assumed the woman would have been struck by the car. That's very common. People draw inferences. So you need to, a good investigator is going to probe with great detail to clarify, is this what you actually saw, perceived, or is this something that you may just be concluding? Are they incorporating other information that they've obtained, either consciously or unconsciously? Is their accuracy consistent with the expectations for this individual? People are going to vary depending on their backgrounds, their cultures, in how they provide information, what quality of narrative they can provide. Is it consistent with training and experience? So again, the trained police officer versus the untrained civilian. It's important to know what someone does. If someone has had a past experience, if someone served in the military, where they had training or experiences that should make them a good storyteller. That's very important to know. And then people vary in terms of their personality and communication style. One person may be very outgoing, may give you a very detailed, flowing narrative. Someone else may be shy and more hesitant, and you may need to pull that out of them by asking some more specific questions, being encouraging, providing some feedback that you wouldn't have to do with the other more outgoing person. Are they responsive to the questions? Are they evasive, or do they provide a non-answer? Does the officer use sort of abbreviated conclusory statements like "for officer safety" or "it posed a threat" without providing specifics? Do they give an answer that doesn't really address the question, like "I wouldn't say or do that," or "it's not my practice to do that," rather than confirming or denying whether they said or did that? Is their account seem rehearsed or unrehearsed? And this goes to whether they've given prior statements, written anything about it. And again, demeanor, that's a very broad subject area. We could devote an entire training to that. Is it consistent throughout their narrative, or does it vary in terms of detail, in terms of the apparent candor, and if so, why? Could we have next slide, please? So obviously, if they've given statements to others, if they've given interviews, it's very relevant to determine how much time elapsed. What are the intervening factors? Have they been exposed to other information or opinions? Intervening events. If you're interviewing an officer 3 months after the incident that involved a detention or a traffic stop, how many other traffic stops or detentions have they made? And is it possible they might be confusing something that happened in one of those other stops with what they're telling you about, particularly if they didn't memorialize it at the time through some type of report or statement? Is the first civilian, have they had any intervening contacts with police or the criminal justice system that's going to skew their perspective? Community attitudes and influences. So a good example of this would be someone might give an immediate statement about an officer-involved shooting to the police. There might then be a huge community outcry about that. And that person who lives in that community may cause them to question their perceptions. Or any of the inconsistencies can be explained by these factors. As I mentioned, contemporaneous statements to others, particularly where in one-on-one encounters where there's a complaint and the officer, can be very valuable. This is often valuable evidence in sexual harassment investigations where you have no witnesses, but the victim's contemporaneous statements to friends or coworkers or their observations of the emotional state can provide powerful buttressing of their credibility. Can we go to the next slide, please? So bias. Obviously, you wanted to explore someone's relationship to any of the involved parties. This is something that jurors are always asked. Do they know how any of the individuals who are going to be providing testimony? The relationship to institutions. Do they have friends or family in law enforcement, in the criminal justice or legal system? Any involvement with advocacy organizations, with the media? And their attitude towards institutions and entities, particularly law enforcement, the criminal justice system. Do they believe that it's fair, that it's or rigged? The investigative process and the oversight entity. Do they seem to have a stake in the success of the investigative process or the hearing process? Do they respect it or disdain it? Do they think it's fair and reliable? Have they had past experiences with this oversight entity that might affect their attitude? Maybe they're very skeptical that it's going to do a good or fair job. Can we go to next slide, please? So motivations, obviously, do they have any interest in the outcome of this investigation or process? Are they facing jail time? Is there a lawsuit? Is there a reputation at stake? As I mentioned, in community standing, where I mentioned the officer-involved shooting. Is giving information that might be counter to community attitudes going to diminish their standing of the community, and might that be an influence on them? Do they have a motive to lie? And if so, what's the consequences for them for lying or telling the truth? If they have lied, what's the context of the lie and why have they lied? So for a police officer, it might be to protect fellow officers. For an arrestee, it might be to deny criminal activity, to protect an associate who was not arrested, not known to police. Obviously, attitudes towards race, ethnicity, gender identification, sexual orientation, socioeconomic status. This can be expressed in past incidents, pattern indicating negative attitudes towards particular groups in statements, such as on social media, the emails or text messages. Many of you know San Francisco had a very unfortunate scandal with officers sending very virulent racist text messages to one another. Through mobile video terminal messages. Is there inferred bias? And you may be able to establish this by analyzing detentions, traffic stops, arrests, uses of force, determine it. Can you find a statistically valid pattern of disparate treatment by this officer? I'm going to go quickly through the other information. Inconsistencies, can we, yes, we have that slide. The investigation should address all significant inconsistencies, should look at any fact or statement can be verified or contradicted by other reliable evidence. If there's a video, as where there often is, you want to determine, was it viewed, when, where, how many times, what did the individual see that was new or different, how did that affect their recollection? If you're dealing with an officer's viewing of a video, you want to find out, did they write a statement or report before or after viewing the video? And did they write a supplemental statement or report after viewing the video? If someone is seeing the video for the first time, you obviously want to do the interview, then show them the video, then go over it with them and seek an explanation for any inconsistencies. Don't assume they were lying. People have many reasons for misperceiving things or misrecollecting things. Obviously, you want to get any video of the incident, but you also want to obtain video footage from locations near the incident. That might show the presence or activity of witnesses before and after the incident. It may also allow you to ID other unknown witnesses who might have been nearby and seen it, but don't appear in the video of the incident itself. If there are other parties and witnesses, is there an acknowledgement of inconsistency? Is there an explanation for that? And you need to evaluate how significant is that inconsistency. And can we have the next slide, please? Plausibility and reasonableness. For law enforcement, this is going to be, is this consistent and plausible in light of their policies and training, their established or accepted practices, and an officer's past behavior? And if it deviates, what is the explanation? So if your complainant says, the officer asked me if I was on probation and parole, and you contact 8 other people that officer contacted that same day, and they say he didn't ask me if I was on probation or parole, well, that shows an inconsistency that you're going to want to explore. Expectations for the officer. Are they experienced or inexperienced? Do they have specialized knowledge or training, such as a SWAT team, veteran narcotics officer, where they trained in crisis intervention? For civilians, is what they're saying consistent with their physical abilities, their ability to see and hear? Could they do what is described? Or perhaps do they have a limited range of motion because of an injury or an illness that would prevent them from taking the physical actions that the officer said they did? And then something I love, just doesn't look right. This is your gut feeling, something here is not right, and what is the possible explanation? Next slide. If there's an admission of untruthfulness, what's the significance? Is it an intentional falsification? Is it a material fact? is it an isolated falsification? And how is this untruthfulness disclosed? Did it come out voluntarily? When it was revealed, did the individual acknowledge it or contest it? And what is the explanation? Does someone make an admission against self-interest? So does complainant say, yes, I was involved in this criminal activity, I was selling drugs, but the search was illegal, or the officer used unnecessary force? And next slide. So I think John touched upon this. Next slide. And so I've put a lot of these factors into a credibility checklist. That's one of the attachments that you can use. I'd be interested if people do use it, how you use it, and would love any feedback and suggestions. And I think we should move on to questions.
Thank you, John and Jayson. We do have a few minutes for questions, the first of which is, what is the best way to establish credibility when video clearly disproves the person's recollection? Is there a way to determine poor recollection versus intentional misleading?
Well, I think the first issue I would probably look to is the opportunity of this other witness to perceive the events. So I'll give you two examples. Say we have a police officer who has a body camera, and the body camera shows events happening right in front of them a certain way, and you can see the officer's hands moving in the video such that it becomes apparent that they're paying attention to what's straight ahead of them. They're not looking to the left or the right. But then the officer's statement in an interview is completely different. That would certainly be a really significant discrepancy that would make you think the officer is not credible. Why might be another question. If the officer's story paints the officer in a much better light and the video shows that the officer conducted himself in a way that is a form of misconduct in your jurisdiction, then maybe that is especially meaningful, and perhaps that shows the officer is not being truthful. But on the other hand, if you had an example where you have, say, a storefront video that is looking at a sidewalk at a 90-degree angle, and it shows some people running by in a certain way, but then the other witness you're talking to was a good ways down the street on the sidewalk looking from a different perspective, that 90-degree angle and the additional distance might entirely explain the reason why what they're saying is completely different from the video. So I'd say first and foremost, take a look at the perspective that each offers. Video is great, but just like a person, it has a perspective. It looks in a certain direction, and it captures only a certain part of the action. So you have to take that into account when you weigh how credible even the video is.
And we also have to remember that people are not cameras, and they don't perceive and recall things as cameras do, 24 frames a second or 30 frames a second. We may miss things, we may overlook things, our attention may be diverted, so it's something you need to explore.
Before I ask the next question, I just want to remind all of you that you can type your questions in. The area where you will type those in is on your control panel that popped up when you joined the webinar. And if any of you want to ask any additional questions. But next, we do have a question in relation to the question you just answered. Do you feel that investigating allegations of police misconduct has become more or less difficult with the increased use of video?
Well, I'd say in one way it's more difficult because now you have more evidence to sort through, and you might also find it's a little bit of an IT challenge to make sure you've stored all that video appropriately. I think that said, it is easier in the sense that you have that much more information. And I think the more information we have, often the more comfortable we are with making a credibility determination. And having that extra video, I think, while it's some more work, usually does make the the work that we're doing easier at the end of the day, or at least makes us feel more comfortable and firmly rooted in the credibility determinations we make.
And I would agree. I remember 15 or 16 years ago talking to some community members who were in the equivalent then of a cop watch program, and asking, what can we do to establish proof? And I said, the best thing you could do would be to carry around cassette recorders. And they said, yes, and I'm sure that when we take those out, the police will be very happy and won't take any action. Now, of course, now everyone has a cell phone with a video recorder on it. So it means there are that many more sources of information. So I like any information that's going to add to the understanding, even if it's going to take a lot more time. I think it has made things easier.
Okay. Thank you for those answers. We currently don't have any more questions in queue. Oh, one just popped up. By and large, officers are responsible for turning their body cam on and off. Are there usually guidelines set forth, or is it solely up to the officer?
I think it varies from jurisdiction to jurisdiction.
Yeah, that's my understanding as well.
Mm-hmm.
And I've heard of jurisdictions debating whether the officer should be required to turn the body camera on in every interaction or only certain kinds of interactions. Apparently some body cameras have a mute button as well, so there may be rules about when the audio muting function should or should not be engaged. For a lot of agencies, I think there may not yet be rules, and if your relationship with the agency that you're overseeing is such that you can have a role in that policy conversation, I'd recommend you get involved in it and figure out what rule you would like to see and make sure it's been memorialized. I know a lot of jurisdictions are working on this issue right now, and I would expect it to continue to be one that continues to evolve over the next couple of years as we see how these differing policies in one city or another perform.
I think the Oakland, California Police Department requires officers to turn on their cameras in a set of circumstances and can discipline an officer if they fail to turn on the camera. And that would be something that would be investigated as to why they did not turn on the camera. Going back to that first question, since we seem to have a little bit of time, about discrepancy between video, it addresses a point I made. I investigated a case where we had a very good video of an entire encounter from a bystander, and I interviewed the officer who had not seen the video, then showed him the video, and there were some very significant discrepancies. And he said this was because of the stress he experienced because he had taken a folding knife from this individual. And there it goes to an officer's experience. This officer had spent a number of years in a highly specialized SWAT unit. And I asked him whether he had been trained and had experience dealing with highly stressful situations involving weapons. And he had to acknowledge that he did. And that undercut his claim that the high stress of taking this knife drastically affected his recollection of the incident. And that was a significant factor in evaluating his credibility.
For those who want some more detail about body-worn camera policies, you can find the San Francisco Police Department's current body-worn camera policy. If you go to the San Francisco Police Department's website, there's a section there for Department General Orders. Order 10.11 describes our body-worn camera policy. It has 13 situations where officers must activate their camera and 3 where they are prohibited from activating their camera, such as strip searches. So if you find that useful, you might want to check that out.
Related question, do either of you have guidelines or best practices for if officers should make statements before or after viewing footage?
I think that is a question where you'll probably find as many answers as there are people who have looked at it. here in San Francisco, our current policy is that we allow officers to see body camera footage before writing an incident report about that same incident. And in officer-involved shootings, they're allowed to see it as well before making a statement. That said, I know there are a lot of people in our community who advocated for a different rule, that officers not be allowed to see it, at least in the case of officer-involved shootings, until after they had made a statement. I certainly have been to a lot of trainings where experts in the field debate pretty vigorously which method is going to get you a more accurate statement. And I know there's also debate about whether it should be an across-the-board rule that officers should see the video before making a statement of any kind, or whether that rule might vary depending on the situation, like, say, having one rule for officer-involved shootings and another one for ordinary encounters that are just being written up in an incident report. I myself don't yet have a strong opinion about that. Other people in my agency have taken the lead on that, and I'm waiting to see what I learn from the evolution of this policy and how it works in the field.
The New York City Office of the Inspector General, headed by former NACOLE President Phil Ure, did a very extensive analysis of recommended policies around the country and the literature. And if you go to their website, you will find that I think so far it's the most comprehensive report on policies, and they recommended that officers not be allowed to view body-worn camera footage, but that is not the policy for the New York City Police Department. Eric Daigle, D-A-I-G-L-E, who's been a speaker at several NACOLE conferences. He's an attorney who represents police officers, former police officer himself. He has a regular blog posting on legal updates, and he has posted a number of extensive articles on why officers should not view the video because it feels it will undermine their ability to communicate their state of mind at the time they made a decision. They will be providing information from the video rather than from their own perspective and their own emotional state. So I recommend that you take a look at those. Those are two very good sources of information with opinions on this issue.
Thank you. I think we have time for one more question, and that is, they've prefaced it with, they know it is a broad topic. However, can you briefly discuss credibility as it relates to mentally ill subjects, the developmentally disabled, or subjects under the influence?
Well, that could be a whole nother training, but I think the short version that I'd give to that is, most of the time, if you're an investigator in a case like this, you're not going to have an opportunity to make any kind of scientific or medical diagnosis of the person's issues, right? Nor would we have the expertise to do that correctly. So we probably should, on the other hand, if as you're going through the interview process with a person of any background, they start exhibiting some of the factors you've seen in these credibility determination factors we just talked about, you should make a note of those. So, and some of them may pop up in ordinary parts of the interview. One interview technique people sometimes use is to start the conversation with the witness talking about fairly ordinary things, like, how are you today? How'd you get here today? Do you have questions about the interview before I start? Maybe walking through some ground rules about, I'm going to ask a question and I'd like you to wait for the whole question until you answer it. How's that sound? I want to make sure we get a good recording of all of this, and see how the person performs. And if they start almost immediately showing signs that they have memory, perception, or narration problems just on these simple introductory questions, that's something you might want to note. I think it's also important to distinguish between people who have an affect or a mood or a behavioral tic, you might say, that is off-putting from factors that are laid out in jury instructions that really go to credibility. I think it is easy to have someone, say, who maybe uses a lot of obscenity and seems really agitated in the interview, and to find that personally off-putting and then determine that that individual doesn't have a lot of credibility. And I think that's not a good practice. I would recommend instead looking to the content of what they're saying to see if they're perceiving, if they're remembering, if they're narrating, even if perhaps the way they treat you isn't what you hope for. And I think that's especially important with people who have a history of some kind of abuse. They might not be the most personable individual when you meet them, but they still will know when they've been mistreated and can articulate it.
Yes, it's my experience that people with mental health issues often draw more police attention. They may be more challenging for officers to deal with. So someone can come in and give you a narrative that contains some obviously imaginary allegations, such as radio waves are being beamed at their head. And they also may have some very specific allegations regarding an officer's actions, statements he made or things he did. So you need to evaluate all of that and see what you can prove or disprove, and recognize that someone can, in the same statement, give you an imaginary claim and also a truthful, valid claim about something that happened. Great example I have is I was coming back from lunch one day and someone was in the middle of the street screaming, punching at something imaginary. And 15 minutes later, he was in our waiting room to file a complaint. But he was very calm. He provided a coherent narrative. He was specific about the things he was alleging, and I addressed it that way. So you have to look at the totality of the situation regarding someone under the influence of alcohol. I don't know if you mentioned drugs. Then you need to find out how much alcohol they consumed, over what period of time, what their weight is, what effect it had on them, what other people may have perceived. Some people can drink a lot of alcohol and have one effect, and some people have a small amount of alcohol and have the same effect. So it's somewhat situational, and you just need to see what elements of what they're telling you can you prove or disprove. Cami, are you there?
I'm sorry, everyone. I was on mute still. We have a few more questions, but I am going to forward this on because of the time running out, forward this on to John and Jayson to answer. As all of you can see, their contact information is on the screen, so if you'd like to contact them with additional questions, please feel free. I want to thank them both for sharing their valuable information with us today, and to thank all of you in attendance for being with us and taking a moment to complete the online survey that all of you will be sent shortly. If you are part of the viewing party, if you could please indicate in the additional comments section approximately how many people were in attendance at that viewing party, it would help us for planning future webinars. Our webinar series does still have several exciting topics to address later this year. We are excited to announce that in July we will hold our next webinar, which will explore strategies for successful community engagement. Please watch your inbox for additional information about upcoming webinars, including dates and when registration will open. We once again thank all of you for joining us today as we continue bringing together individuals and agencies working to establish or improve oversight of law enforcement in the United States. Thank you all and have a good day.